Yo, 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 it's your boy, the insurance junkie, your fiduciary fella, the all-star advisor Alonzo Hall, and I've returned today with another ADH wealth solution. Today, we'll begin to discuss fulfilling all of your financial needs. To contribute to channel growth, the links are in the description. To schedule an appointment of your own, or to purchase life insurance directly up to $1 million with no medical exam and an instant decision, my information is in the description. Lastly, make sure you hit that like, drop a comment, subscribe, and hit that notification bell so you're made aware every time I release new content. And as always, share, share, share. And now, here's our next feature. Salute, 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 salute. It's your boy, the insurance junkie, your fiduciary fella, the all-star advisor, Alonzo Hall, and I've returned today to weapon tap on your head with another ADH wealth solution. Today's article is from the Jamaica Observer, and it's on wills, ownership, and a division of property. A January 24th, 2022 article, kind of a help ask for Margaret Macaulay. Before we go in, ladies and gentlemen, make sure you hit that like, drop a comment, subscribe, and hit that notification bell so you're made aware every time I release new content. And as always, share, share, share. Lastly, to contribute to channel growth, to purchase life insurance directly up to $1 million with an instant decision and no medical exam, or to schedule a one-on-one appointment with a licensed financial professional, the links are in the description. As we proceed to give you what you need, it says here, the writer wrote in, "Dear Mrs. Macaulay, my uncle made a will properly executed by an attorney in 1994. He subsequently executed a trust document properly executed by an attorney in 1996. Within the trust document is a pour-over will. He is deceased as of 2020. My question is A, is the pour-over will recognized as a valid document for property conveyance in Jamaica? And B, if not so recognized, being contained in the trust document, would the 1994 will be recognized as a valid document for property conveyance in Jamaica, even though there was a subsequent trust document which is not recognized as valid in Jamaica? I am a 70-year-old Jamaican, and my uncle, a Jamaican, migrated to the U.S. in the early 1980s. I was left as the executor of his 1994 will and the 1996 pour-over will, and also as the successor trustee of his trust. His wife predeceased him, and neither he nor his wife had any children. The property in Jamaica, to which he held title, is to be divided up for the children of my uncle's parents and or their successors. I need to be able to give ownership of the subdivided property to the heirs of his father/mother, as was decided by the family prior to his death at age 89. Now, Mrs. Macaulay responds here. Well, reader, it is clear to me that I cannot answer all that you would need to know in order to move ahead with the legal processes necessary to enable you to be legally registered on transmission of the title or titles of all the estate's real property or properties, so that you can then legally transfer the parcels of land due to each of the beneficiaries of the estate. I've not had sight of the 1994 will, the trust deed made in 1996, within which you assert is a pour-over will. I cannot assess whether you are correct in your assertions and identifications of those documents, nor can I form an opinion about the contents and their validity or invalidity in law in Jamaica. Really quick, guys, This is why it's important to not wholeheartedly listen to people like Sue Zorman or Dave Ramsey, because they get a brief glimpse of your situation, kind of like this person did, and then they try to give you definitive answers. Now, when it comes to things like getting out of debt, Dave Ramsey is great, but then he also has things like his financial coaching university. He's not a licensed financial advisor, so it really isn't the best to listen to him. He'll keep you at the realm of being consistently middle class. But again, to get out of debt, it's a great thing. So let's continue. Most of the time, someone who's about what they're truly about it will give you an answer similar to this. I can't really give you a definitive answer without really looking at XYZ documents. And, that's solely because that's kind of the situation. Now, they're going to give general answers. Generally, the trust must be in existence before the will is made, and then if a testamentary trust is created in the will, this often functions as a pour-over will, which places the property or properties dealt with in the will within the earlier established trust. I can say this, that the term pour-over will is not often used in Jamaica, where the simple and more straightforward method of creating a testamentary trust in one's will is more commonly used. With a named trustee appointed, especially for gifts to very young children, for the safety of the bequest until the child's majority or any later age when the trust is stated to end. You really need to take the documents in your possession to a lawyer experienced in estate law and practice, and have that a person assist you to interpret them and the law which must be applied, and ensure that your distribution of the bequests is made properly and according to law, and that you obtain your entitlement as executor and trustee. You really must do this because there are several matters which have to be examined for an estate lawyer to draw up a revocable trust deed, which is recognized as a living trust, and so it can be changed during the grantor's lifetime. They become operative after their execution during the grantor's life, while a will only comes into operation on the death of a testator. When you consult a lawyer, she or he must first ascertain the issue of the validity of the will and trust deed, and if they are, which of them takes precedence over the other if they are in conflict, as they were made 2 years apart. I'm not in a position to do any of this and answer your questions, and it would not be sensible of me to attempt to do so in such a vacuum. I write this column to assist people to understand how the law applies to problems they have, and advise them to obtain the services of a lawyer to whom they would be able to relate their circumstances in greater detail. In your situation, reader, I really would need to read and consider the status of the will and the trust deed, which you say has a pour-over will in it, and apply the applicable law to them in order to give you a sensible answer to your questions. I therefore cannot do so, and do not wish to mislead you or any other writer or reader in any way. Your situation is not a simple application for the probate of a will. It involves a serious examination of the two documents and then the related law applicable to them. So, I suggest very strongly that you should make every effort to find and retain an experienced estate legal practitioner who can assist you after your complete disclosure to her or him. I wish you all the very best and success, and assure you that I have pointed you in the right direction. And again, this is from Margaret May Macaulay. She's an attorney at law, Supreme Court mediator, notary public, and women's and children's rights advocate for the Jamaica Observer. Ladies and gentlemen, that's it for today. Make sure you hit that like, drop a comment, subscribe, and hit that notification bell so you're made aware every time I release new content. And as always, share, share, share. Lastly, to contribute to channel growth, to purchase life insurance directly up to $1 million with an instant decision and no medical exam, or to schedule a one-on-one appointment with a licensed financial professional, the links are in the description. With that being said, wipe ass. Work in progress every day and see success. Salute, salute, salute. Hey folks, this last video was sponsored by my company, where we help people like you to reach their financial goals. We do this through a simple conversation where we help to identify and then protect your lifestyle, and then we implement a plan. The process starts at about an hour. So, if you want more information, or you want to schedule a consult, contact me via the information in the description box, and let's talk and see if we're actually a great fit for each other. And remember, ladies and gentlemen, when people challenge you, they don't challenge you to challenge you, but they challenge you to challenge you. Accept the challenge. Thank you, and enjoy life.